Expert reports from doctors Spanier, Steiner, Joyce Myers prove that plaintiff's symptoms are the result of psychotronic weapons attacks upon her person. They prove that psychotronic attacks, compounded by negligent infliction of emotional distress by authorities who do not want to take seriously plaintiff's reports about this crime, greatly impact plaintiff's functioning and cause the serious post-traumatic stress disorder. Fresh evidence, excerpt from answer to FOIA request, proves negligence of RCMP one more time. I forced RCMP to start an investigation, and they started it in the middle of January 2009 and ended on the 9th of February 2009. This investigation consisted of one conversation with Lei Chen, and they immediately stopped this investigation after he confessed that he had studied psychotronic weapons and their influence on psyche of people. It proves that RCMP owed me a duty of care, but the investigation was negligence, since they stopped it after Lei Chen confessed that he was aware about psychotronic weapons and studied their influence on psyche of people. RCMP didn't come to me with spectrum analyzers and other electronic equipment in order to find criminals who implanted nanomaterials in my system and detect me by means of psychotronic weapons. I don't want to read paragraphs regarding Toronto Police Services because they are almost identical to information about RCMP. I just want to repeat that negligence of the Toronto Police Services may be proved if Constable Corby is put on oath and testifies truth. If plaintiff has actually developed psychotic illness and delusional disorder, the diseases are a result of RCMP and the Toronto Police Service's refusal to start investigation, which sanctioned experimenters through the inaction to stop them, allowed further electromagnetic energy and psychotronic weapons attacks, and therefore harm be done for her. There were no other reasons to develop psychotic illness and delusional disorder. Plaintiff arrived at Canada in perfect health in February 2004. Her family doesn't have any history of psychiatric diseases. She was almost 47 years old when she was labeled with psychotic illness and delusional disorder. She led a normal and healthy life. She didn't drink, smoke, abuse drugs. She attended gym. The only serious stress that she experienced was a stress intentionally inflicted by the effects of electromagnetic energy and psychotronic weapons. Negligence of RCMP and Toronto Police Services officers. Plaintiff claims disability because of psychiatric diseases and psychotronic weapons attacks. Plaintiff also claims tortures and health damage of other kind as a consequence of electromagnetic energy and psychotronic weapons attacks, trauma of left temple, loss of memory and knowledge, post-traumatic stress disorder. She claims poisonous and toxic nanomaterials in her system. She claims substantial financial losses since she is deprived of job and profession because of psychiatric diagnosis and electromagnetic energy and psychotronic weapons attacks. Plaintiff claims loss of trust, love, support and intimacy from family. She claims deprivation of all rights. RCMP and police prevented her from legal right of investigation of crime, defense, proper legislation and proper interpretation of legislation, using psychiatric diagnosis as a ruse to do nothing. Inaction of RCMP and Toronto Police Services contributed to the claimed damages and losses. Issue 5. Did the trial judge err in finding that the case had no chances for success as none of the allegations could be proved? Lei Chen and Rengxian Li were noted in default and actually admitted their crimes. Negligence of the Toronto Police Service may be proved if Constable Corby is put on oath and testifies truth. Fresh evidence, excerpt from answer to FOIA request, proves negligence of RCMP one more time. It proves that RCMP owed me a duty of care, that their investigation was negligent, since they stopped it after one conversation with Lei Chen and didn't look for criminals who implanted nanomaterials in my system and attacked me by means of psychotronic weapons. Fresh evidence, expert reports from Dr. Hildegard Steninger, Dr. Spanier, John Steiner, Joyce Myers prove that plaintiff's symptoms are the result of psychotronic weapons attacks upon her person. They prove that psychotronic attacks, compounded by negligent infliction of emotional distress by authorities who do not take seriously plaintiff's reports about this crime, greatly impact plaintiff's functioning and cause the severe post-traumatic stress disorder. I want to repeat one more time that I have all proofs regarding negligence of RCMP. They owed me a duty of care. They refused to start investigation, and their causes why they refused. These causes were criminal. They refused to investigate just because they thought that I was delusional, and they thought that as Corporal Clamp said to me, we look differently at Canadian laws. They thought that there was nothing criminal in these attacks and their influence on psyche of people. And they demonstrated malice, because if they had found criminals, it would have proved their negligence. So if they are not charged, RCMP and police, they will do all possible and impossible in order not to find criminals. Because one more time, if they find them, it will prove that they were negligent. My appeal was dismissed on the 15th of December 2009, and decision of judges was, while we accept that the appellant sincerely believes the matters complained of, we see no basis on which to interfere with the motion judge's decision. We agree with the motion judge's conclusions that the appellant's current fresh amended pleading fails to disclose a reasonable cause of action, and further that it fails to comply with the rules of pleading as set out under the rules of civil procedure. We know that the appellant was previously afforded an opportunity to file a fresh statement of claim to cure the deficiencies in her original pleading. As we have said, her fresh pleading fails to do so. In these circumstances, we also agree with the motion judge that no attempt to amend the pleading could realistically repair its fatal deficiencies. Finally, the appellant's fresh evidence does not meet the test for admission set out under Sengmuller versus Sengmuller. The evidence now sought to be introduced could have been adduced prior to the hearing before the motion judge on the exercise of reasonable diligence. Further, the fresh evidence doesn't establish a cause of action against the relevant defendants. Accordingly, even if admitted, the fresh evidence would not likely be conclusive of any issue of appeal. The appeal is dismissed. In the particular circumstances of this case, we do not regard it as appropriate to award any costs of the appeal. Of course, it's not true, because I acquired evidence, results of RCMP investigation in 2009, and motion before a judge in the Superior Court of Justice was on the 5th of December of 2008. So of course, I couldn't get this fresh evidence before this motion. And results of the investigation prove their negligence one more time. So I'm going to appeal this decision in the Supreme Court of Canada.